Good morning, everyone, and thank you for joining our webinar today on access to adequate accommodation and housing under the Temporary Protection Directive. My name is Simona. I'm a policy officer with FANSA, and I will be your host for today, together with our director, Frank Spinewin, who will join as we will advance in the webinar. So thank you again for joining. Today's event is going to focus on helping us to gain a better understanding on the right to accommodation under the TPD. And at the same time, we aim to take stock of the ongoing challenges and problems with accommodation as they appear on the ground. Many of you in the audience, of course, would know that at the end of April this year, over 4 million people were registered with temporary protection status in EU countries. And more recently as well, the European Commission announced the extension of the temporary protection until 2025. Therefore, we believe that there is a continuous need for support with accommodation for those who arrive in the EU countries. Therefore, this conversation remains highly relevant. So we are very glad to be here today, as also because we see this topic of high relevance in the context where in Europe we have had a crisis of affordable housing and overwhelmed asylum systems in many member states. And all these factors have made it difficult to identify solutions to ensure proper access to accommodation for all people fleeing the war in Ukraine in the past over 1 year and a half. We have noticed in this period that available accommodation solutions under the TPD have not always complied with established standards for reception. And furthermore, some groups have had problems, have struggled to access accommodation at all. Here we can mention Roma or LGBT people or third country nationals fleeing the war in Ukraine. And last but not least, we have also seen a risk of homelessness among those fleeing the war and arriving to member states. So we want to look at all of these factors today and to engage in a conversation about these issues with our members, our partners, representatives of the European institutions, and of course, also with the audience. So I would kindly ask you to share in the chat and in the Q&A section your experiences, where you're joining from, and any questions that you may have as we go through the presentations. I'm not going to take any more space from our time, so I'll just say that we are very grateful to have with us in the webinar very experienced and engaged speakers in the area of migration and asylum. And without further delay, I will introduce the structure of today and the speakers who will follow. So we will be together for 1 hour and a half, and we'll have 2 panels. The first one, which I will moderate, is going to focus on the right to accommodation under the TPD, looking at how it should be understood and how it is implemented in practice in certain countries. And we will hear first from our colleague Irina Hnasevich, who is Senior Legal Officer at ECRE. And then we have with us Jakub Wilczek, the president of the Polish National Federation for Solving the Problem of Homelessness, and Jules van Dam, director at Tussen Voorziening and representative of the National Valente Association in the Netherlands. And they will introduce themselves and pronounce their name properly. I'm very sorry for any mistake I've made. And then we'll have a second panel chaired by Frank Spinewin, who is also currently joining us, FANSA director, and he will be joined in this panel by Katerina Dimitrakopoulou, who will be with us shortly. She's head of sector on integration at DG Home, and Thomas Jezekiel, who is also here with us, head of the reception and vulnerability sector at the European Union Asylum Agency. And in this panel, we will look at, we will learn more about what was done in the past months from the EU institutions and how they worked with member states to support access to accommodation. And also we hope to learn more about what the future holds. So without any more delay, Irina, please, I would like to pass on the floor to you. If you can share your screen and walk us through how should we understand the right to accommodation under the TPD and in the context of the common European asylum system. Thank you.
Good morning, everyone. Thank you so much for the kind introduction, and I will start talking about the right to suitable accommodation. As it was mentioned, I'm a senior legal officer at the European Council on Refugees and Exiles, and I've been working on the litigation-related issues when it comes to the implementation of Temporary Protection Directive. And also last year, ACRE published a legal note, which I authored, on the right to suitable accommodation. So today I will talk a little bit about the main findings points that we presented in the legal note. So my role here would be more to set the legal basis for what does it mean and the right to suitable accommodation and how it could be interpreted under the Temporary Protection Directive. I will not be sharing any practical implications of this right, which I assume my colleagues in the panel, Jakub, will also be talking about the Polish experience. So I will start already. So Temporary Protection Directive is one of the instruments of the Common European Asylum System. And it was, we call it the first phase directive, first generation directive, which means that it was never recast, it was never reformed, it was drafted in 2000, so it's been 23 years already since the draft was adopted, which also means quite a lot has been changing over the years, and the Common European Asylum System has been developing, and there by now were 3 generations of instruments. So also the interpretation of certain rights have evolved, which did not happen for the Temporary Protection Directive, which until recently was supposed to be even repealed. Luckily, it's still at place, and we see that it was a very useful, very timely instrument when it came to the war in Ukraine and the number of displaced people seeking protection in the European Union. So as I mentioned, the TPD is part of the Common European Asylum System, which forms the secondary law in the European Union. And this means that it has to be interpreted in the light of the EU primary law, which very importantly consists of also the Charter of Fundamental Rights of the European Union. And later I will also explain why it's so important, especially in the context of the interpretation of the right to suitable accommodation. Okay, so how it was drafted, the Article 13, it includes the obligation of the member states concerned to provide temporary protection beneficiaries with suitable accommodation, or to provide the means to enable to obtain housing, which includes also the obligation to provide necessary assistance with regards to social welfare and means of subsistence if displaced persons do not have sufficient resources. So Article 13 became one of the most important articles, arguably, under the Temporary Protection Directive. It ensures one of the core rights guaranteed by the TPD. There is lack of common definition. The interpretation and implementation of the right to suitable accommodation varies across the member states and varies a lot. Also, it's due to the fact that the directive was drafted a long time ago, and even the explanatory memorandum norms, they were referring to the possibility, for example, to interpret this right, to use the reception system that is at place for the asylum seekers, also for the temporary protection beneficiaries. In some states, indeed, did so, but it was not a common approach, and there was no common approach established per se. The TPD also does not define the form or level of accommodation to be provided. What it does provide for is that the special needs of displaced persons have to be taken into consideration, and necessary assistance has to be provided to unaccompanied minors, persons who have undergone torture, rape, or other serious form of psychological, physical, or sexual violence. Unfortunately, also, as by now we also know, and in practice, the process of receiving temporary protection is completely different from the ones that we see in the asylum system. It means that there is no screening for the special needs of persons applying. People who apply for temporary protection, in the most cases, the procedure is quite fast. There is no interview proceedings, which means also there's no screening process, unfortunately, for that. The practical implementation and provision and covering the special needs of people who ask for accommodation, it was practically impossible. So going back to the explanatory memorandum of the Temporary Protection Directive, it was indicated that member states' obligations as to the condition of reception and residence of persons enjoying temporary protection have to be determined, and this obligation should be fair and offer an adequate level of protection to those concerned. So quite abstract, they were not determined, as we know, and it does not provide any further explanation as to how and what could be regarded as suitable accommodation. Here I've indicated a number of articles of the EU Charter, and why they're important also because since we do not have particular definition, what is suitable accommodations, what are the conditions, it is very important to also see the core, the background, which also always has to be considered, is the EU Charter that includes Article 1 is the right to human dignity, which is the fundamental right and underlying all other human rights, including the right to dignified standard of living. Also, the right to suitable accommodation of persons with specific needs has to be interpreted in the light of Article 24, meaning the protecting the rights of the child, which means also taking the best interest of the child, always, whenever any decision related to the child is taken. Article 25 on the rights of the elderly, and Article 26 on the rights of persons with disabilities. And also Article 34 provides for the right to social and housing assistance to ensure a decent existence for all those who lack sufficient resources in accordance with the rules laid down by the Union law and national laws and practices. I've also indicated the Article 47, which means the right to effective legal remedies in terms of access to suitable accommodation. This is one of the problems that was also many persons, many temporary protection beneficiaries face, not only in the context of suitable accommodation, but in the context of temporary protection overall. Very often, in most of the states, there was no effective remedies available. There was no administrative proceedings set in place, if someone would be denied the right to suitable accommodation, there is no recourse. You cannot appeal to this decision. You cannot do basically anything, and it also deprives the person of any right to seek justice in this situation. So I was thinking that the access to effective legal remedy is one of the crucial also when it comes to the right to suitable accommodation. So I also indicated some, as I mentioned, that the TPD as being part of the common European asylum system has to be interpreted within and in the light of the asylum, common European asylum system. What it means is also because since other instruments have been recast, they've been reformed, and some rights were enhanced or they were provided for in more detail, which means the interpretation of the TPD with the rights that are not so clear as we have it with a suitable accommodation have to be interpreted in the light of other instruments, such as, for instance, Reception Conditions Directive. And here we have the interpretation of the Court of Justice of the European Union, referring to the reception conditions under the asylum system. And here we all very often have the reference to a dignified standard of living provided by the Charter, as I've mentioned, by Article 1, and which also that gives us the idea what does it mean to have the suitable accommodation. And in several cases, the CJEU talked on the issue, and here in the Hagbin case, the CJEU stated that with regard specifically to the requirement to ensure a dignified standard of living, respect for human dignity within the meaning of this article, requires the person concerned not finding himself or herself in a situation of extreme material poverty that does not allow the person to meet his or her most basic needs, such as place to live, food, clothing, and personal hygiene, and that undermines his or her physical, mental health, puts that person in a state of degradation incompatible with human dignity. So here we see that the right to suitable accommodation involves is considered to be a basic need that absolutely has to be provided, and it has to be also going in combination with having clothing, food, and personal hygiene. Moreover, what I also wanted to mention that what the common European asylum system sets are the minimum standards. That means that it's the absolute minimum threshold that has to be provided and cannot go below. It can only be improved by the member states. The Court of Justice also clarified the meaning, what does it mean to ensure the dignified standard of living. And again, in Hagbin case, the court stated that this verb is used to guarantee the standard of living continuously and without interruption. It also means that if the person, for instance, stopped being or has to be transferred to a different state in the context of the Dublin regulation or return procedures, before this is exercised, this person has to receive reception conditions, the minimum standard of them. And also to ensure that the authorities are responsible for the provision of material reception conditions, guaranteeing that such standard of living can be provided not only by the state authorities, but also private, natural, or legal persons in order to carry out under their authority this obligation. This means that also the Reception Conditions Directive and the interpretation by the court, that it's not always the state who has to provide, but they also can delegate this obligation as long as they fulfill their responsibilities, it's fine. What TPD also allows that the providing accommodation can be provided either in kind or in the form of financial allowance, but this financial allowance has to ensure a dignified standard of living again, and has to be sufficient to meet the basic needs and be adequate for the health of the applicants. Failure by the member state to provide dignified reception conditions would breach both EU and international law, and also, most importantly, cannot be justified by the large number of persons arriving in the country. This also was further confirmed in the Sassiri case, where the court stated that it must be pointed out that for the member states to ensure that those bodies meet the minimum standards for the reception, saturation of the reception networks, not being justification for any derogation from meeting those standards. This also can be applied in the context of the temporary protection, especially for the states that received the largest number of protection seekers, such as Poland, as I'm sure my colleague will be talking about later. Access to justice, as I briefly mentioned before, TPD does not include any separate provision allowing for judicial review for the decision, and it also the decision regarding social assistance or access to suitable accommodation. But it has to be pointed out that given that it is not provided in the directive or provided within the national law, given that the European Charter on Fundamental Rights is the primary law, it has the direct applicability. So the Article 47, providing for effective legal remedies, has to be applied directly, as this right is the fundamental right, and everyone has to have the right to judicial recourse. I'm well aware about the practical complications about this. I'm trying to also set the basis how it should be and how the law provides for the minimum standards which have to be followed by the member states. But also very important point that the Temporary Protection Directive does not refer to the definition who are vulnerable persons, but this is something that was further developed in the second generation Common European Asylum Systems instruments. And here I've included also the case law of the CJEU, stating that member states must ensure that the total amount of the financial allowances covering the reception conditions is sufficient to also provide for adequate standard of living for the health of applicants and capable of ensuring their subsistence, enabling them in particular to find housing and with regard to their specific needs. It has to be also sufficient to enable minor children to be housed with their parents so that the family union is maintained. Concluding the EU system, the EU standards for the reception and for the suitable accommodation, I wanted to reiterate that there can be no derogation within the minimum standards of the protection provided by the Reception Directive, even on the temporary basis. And here we have to draw the parallel with the Temporary Protection Directive, which is designed to ensure the minimum standards of protection in the event of high numbers of displaced persons. And the right to suitable accommodation is included in the list of minimum standards and should be provided by the authorities with regard to special needs of temporary protection beneficiaries. In the legal note, we also looked at the standards of international law. We looked at the standards of the Council of Europe, of the European Convention on Human Rights, and here we saw that the European Court of Human Rights also referred to the right in the context of the prohibition of torture, within the context of the right to family and privacy, and that the reception conditions in other states were absolutely crucial condition also for the cases of deportation or Dublin regulation transfers. We also looked at the European Committee on Social Rights, and here also a shout out of the work of FEANSA filing collective complaints to the European Social Committee, who gave their opinions with regards to including the right to adequate housing, and it also gives the idea how it should be interpreted. For instance, in one of the cases, Franza versus the Netherlands, the committee stated the criteria for a state to comply with Article 31(2) of the social charter, and the committee specified that the right to adequate housing requires a state to keep track of significant statistics regarding persons' needs in terms of adequate housing, available resources, and the outcomes of any measures taken by the authorities. The committee also found that even though the authorities had recognized the inadequacy of the shelter for vulnerable individuals, they had not taken any steps to rectify the issue. So in the legal note, we looked also in the European Committee on Social Rights interpretation of this. We also looked into the international law standards and standards regarding the people with disabilities and their access to adequate accommodation, if that accommodates their specific needs, and how their specific needs should be addressed. Same goes for the Committee on the Rights of the Child, children being regarded as a vulnerable group. And also, this is what I forgot to mention, that displaced persons regarded by the European Court of Human Rights as a vulnerable group per se. So we are talking here about the double vulnerability of these persons, as there are people who are already vulnerable by being displaced, but also displaced people having specific vulnerabilities due to their individual circumstances that has to be taken into consideration as well. The Court of Justice of the European Union has not given any interpretation on the right to suitable accommodation under the Temporary Protection Directive per se, which means that lawyers have a chance to put pressure on their national courts to, for instance, direct the questions for preliminary rulings of the CJEU or so, but this also comes down to the right to effective remedy, because to initiate the question to initiate any judicial review of the denial of suitable accommodation means that there has to be an administrative proceedings for this, and there's none in most of the cases. I also wanted to point out that ACRE published the compilation of practices within the context of our AIDA asylum information database, also on the social economic rights, and we also analyzed the right to suitable accommodation within 22 countries and that provided us with the reports. And I'm open also to questions. I feel I overstayed my welcome already, and thank you so much again for the invitation. I'm looking forward to the discussion.
Thank you, Irina. That's a very comprehensive overview of the right to accommodation. And thank you for pointing out also the work of FANSA and our colleagues from the Housing Rights Watch with the collective complaints. We will go straight to the next presentation as time is running on us, but we do encourage everyone to leave their questions in the Q&A and in the chat, and we'll be also putting some links later on to the resources mentioned. So yes, we will now go to Jakub, who is going to tell us a bit more about the challenges in accommodation as they've been faced across Poland and the risk to homelessness identified in a recent preliminary research conducted by the Federation. Jakub, over to you.
Good morning, everyone. My name is Jakub Wilczek. I'm a president of a national federation that consists of 36 different Polish organizations working with homeless people. And I don't want to speak very much, as my time is very limited, about the situation of refugees in Poland in general. You probably, as people who attend this webinar, you probably are aware of the general situation of refugees in many European countries. I want to focus on the risk of homelessness among the Ukrainian refugees in Poland. So there's, at the moment, there's 1 million registered refugees registered for temporary protection in Poland. 80% of them are women below 60 years old and children of both genders. And why we are looking into the problem of homelessness among refugees. Firstly, because the government is withdrawing the support for refugees. We've already seen the withdrawal of support for families sharing their houses with the refugees. We've already seen the introduction of payment schemes for staying in shelters for refugees. And recently, at the end of September, as a part of government's electoral campaign, because there's elections this Sunday in Poland, the government spokesperson said that all support for refugees is going to be suspended since the new year. Of course, this is impossible to perform, and they won't do that. But this shows that there are growing resentments against the refugees in Poland among the voters, and the government is trying to buy their votes this way. On the other hand, the situation on the housing market in Poland was always dreadful, and it keeps deteriorating all the time. The government's recent programs didn't help that very much. They wanted to improve the situation by supporting the mortgages. The developers or general housing market simply reacted with prices of housing rocketing. It's even more difficult for the refugees to obtain housing right now than it was at the beginning of the war. On the third hand, the government refused to perform the national headcount of homeless people that was scheduled for the beginning of this year. So we have no data on homelessness since 2019 in Poland. And as you can imagine, there's still a large group living in conditions, a large group of refugees living in conditions that can be described as homelessness. To be specific, I'm speaking here about Ethos 5 situation, shelters for people who are refugees or migrants. There's estimated 25 to 40,000 refugees still living in those places. We have no idea how many of them are in Ethos 1, 2, 3, and 4 situations. So we were trying to perform very basic, very preliminary, very superficial research to determine whether there is a risk of homelessness among the refugees and whether there is homelessness already in that group. We've been asking NGOs in Poland, different regions, 47 altogether. So as I said, this is a very preliminary research because what we wanted to do was to interest in financing a bigger research, interest the IOM in financing a bigger research. So far, they expressed some interest, no decision made yet. But this is very preliminary work that is already quite alarming. So first of all, we have discovered that the majority of the NGOs who took part in the research don't service any housing needs of the refugees. So only a minor part of the NGOs involved are dealing with housing problems, and this may also be a problem in communicating to the society that this group needs support in the housing area. Second of all, on the opposite, the same NGOs declared that the main problem among the refugees right now is exactly housing. As you can see, we've asked them about different areas of needs, and they responded that the needs in the housing area are not met at all or met to a very small extent. Then we've asked directly about the risk of homelessness, and half of the NGOs we've been talking to said that yes, there is a risk of homelessness among refugees in their area of operation. And as the major reasons of this risk, they've obviously pointed the rental prices and the lack of social housing. Also other difficulties, but those two were standing out very extensively. Then we asked about the cases of homelessness they are already aware of. Simply speaking, homeless people among the refugees they have met in their work. And nearly half of the asked NGOs said that yes, in their area of operation, there are homeless people around among refugees. And in 1/3 of the NGOs, that was above five cases of homelessness among the refugees. So altogether, we estimate that if, only within this very superficial research, we've discovered about 100 people who are homeless in the understanding of ethos 1, 2, 3, and 4. We also asked about specific groups who are experiencing homelessness among broader categories of migrants and refugees. And as long as most of the NGOs who are supporting refugees from Ukraine said that they do not identify homelessness in this group, there was quite a large group saying that migrants from former USSR who migrated to Poland not related to the war in Ukraine also experience homelessness. Barriers in support, well, obviously, first reason the first problem that limits the support is financial resources or lack of them. But the next place, obviously, lack of housing. Access to data, maybe I will skip it because the time is limited. Generally, our respondents said that there is absolutely no knowledge of the problem in Poland. So further research is very much needed. And all of them nearly said that they are feared that they fear that the situation will explode in the next years because of the reasons I've mentioned at the beginning, withdrawal of support and very difficult housing markets. So the homelessness among the refugees in Poland may be growing very rapidly in the following years, in the next 1 or 2 years, we guess. The only thing we've found out so far is that the problem is there, and we barely know anything about it. So I think the most important conclusion from this research is that further research is needed, but also it is a call to Polish government to start looking at the refugees' homelessness, because so far the social policy department doesn't want to acknowledge homelessness among the refugees, because homelessness is part of social policy department, and refugees is a topic for internal affairs department, and the law does not connect here, so they don't want to intercross their jurisdiction here, which is a very stupid problem, simply speaking, but it may be blocking the support for homeless refugees in the future. Thank you very much. This was a very short presentation. I hope you can later visit our website and download the report in English, which is a bit more well written than this chaotic presentation, I guess.
Thank you so much, Jakub. That's very interesting. And there is actually a request in the chat for a link to the publication. I know you also need to leave before we finish the webinar. So if you can help us with the link before you go, that would be great. And thank you.
Yes, it will be right here in a moment.
Perfect. Thank you so much. We are already behind time, so I'm just going to move straight to Jules. And please, Jules, tell us a bit more about the situation in the Netherlands, specifically in relation to third country nationals and the access to accommodation. And I'll be sharing the screen as you start speaking. Thank you.
Yeah, share the screen when I go to the second part of my story. Not now, maybe. Okay. Hi, my name is Jules van Dem. I'm a director of the Tussenvoorziening, an NGO who provides social service, shelter and housing in Utrecht. We care for about 2,500 people on a daily basis. First, I will give you some figures and information on the policy. Then I will tell you about the current situation, and I will end by explaining the possibilities for the coming months. And as an extra, I will tell you the story of one of the third country nationals. We have around 90,000 refugees from Ukraine in Holland, and the number of third country nationals is 2,900. In my city, we are talking about less than 25. At this point, they have the right to shelter, to an allowance, and the right to work. Most people in this group either work, go to school, university, or care for their family. Some people make use of the local shelters, and others stay with host families. In March of this year, the Ministry of Justice decided that the temporary protection for this group should end at the 4th of September. And the reasoning behind the ending of the protection was the notion that these people have a safe country to go back to. The ministry made funds available for those people who would choose to go back to their country. And if they should choose not to go back, they could apply for asylum. And this means losing the right to work, study, to stay, and they have to stay in the asylum center, reception centers, which are overcrowded at the moment already, where people have to sleep in the streets. At the same time, in March, major doubts arose about the legal basis for ending reception for this group. It appeared that the Temporary Protection Directive, which also included third country nationals, cannot simply be withdrawn. That's why a trial process has been started in recent months to obtain clarity before the September 4 deadline. During the summer, 12 third country nationals went forward to request extension of the protection. This led to various contradictory rulings of regional courts, and on August the 30th, judges in 3 cases ruled that the government should wait with the decision until the decision in the trial process has been made. During the summer, protests grew against ending the protection for third country nationals. The National Association of Local Authorities, the Refugee Foundation, called on the government to give clarity on what would happen to these people once the protection was stopped. They feared that many people would become homeless and that chaos would arise. Fianza and Valente, the national organization, wrote a joint letter to the government requesting an extension of the protection. The director of Valente was interviewed on national television about the whole situation, and the joint lobby proved effective. 2 days before the deadline of September the 4th, the ministry decided to freeze the termination of temporary protection until the Council of State ruled on an appeal. This appeal gets its ruling on October 23rd, 2 weeks from today. We expect 3 options then. The first one is that the Council of State rules that the protection should continue in the same way as Ukrainian nationals are protected in the Netherlands. This would mean that they can stay and continue work or study. Third country nationals who have returned to their country of origin or who have applied for asylum can go back to their former status. There is a possibility that the ministry will opt for appeal on a European level, but experts think that this is not very likely to happen. The second option is that the Council of State judges that terminating the temporary protection is lawful, but also indicates that it must be tested and assessed whether the consequences of terminations are disproportionate in an individual case. This is very confusing and a complicated process that the government currently estimates will require until at least March next year to handle all cases. And the third option is that the Council of State rules that termination of the temporary protection is lawful generically. The government has indicated that it wants to restart the process as normal after the Council of State's ruling. It is important that this restart becomes feasible for municipalities. There is a high risk of forced evictions and homelessness. The local authorities have already indicated to the ministry that this is not possible during the Christmas and winter periods. Local authorities are also discussing with the ministry about the moment when the departure period will start in this scenario. Conclusion. There's no need to say that we hope that the Council of State rules that protection to third country nationals must continue. What I can see right now is that a number of third country nationals have applied and received student visa. Some of them may be entitled to an asylum. Even my organization currently employs one of these people. However, given the fact that these people have been robbed from their future in Ukraine and that they now face the same thing again in the Netherlands, I can only hope for a just outcome. And as an extra, I asked this employer to write down his story, and then you can see him also on the screen if Simone puts him on the screen, and I will tell his story. I am El Mehdi Banatia, and I was born and raised in Morocco. Ever since I was a young child, I have wanted to be an architect. However, due to family obligations, I had to enlist in the army to finish high school, which decreased my chances of getting into the architecture schools that exist in Morocco. Ukraine was an excellent alternative for me because studying there was inexpensive and not too difficult, so I did. I spent 6.5 years there studying, and although there were ups and downs, I really enjoyed that time there and with the people there. When the war broke out during my final year of graduate school, I suddenly felt as though everything I had accomplished over the previous 6 years would vanish, and I wouldn't be able to start over. Unsure if I would be able to do it again, I left Ukraine after waiting for 2 weeks in the hope that the fighting would end. It was heartbreaking to have to leave the country in this manner, and the people who had welcomed me and helped me become who I am. Today, we are dealing with this terrible situation. It took me 3 days to travel from Kharkiv to the Hungarian border, a miserable journey during which I had to sleep outside and worried that I could freeze to death. In Hungary, they assisted us with housing and food. And I started to think again about what I would do and how I would finish my studies. But the university students in Morocco began protesting against our integration in Moroccan university. At that moment, I knew that I had to look elsewhere. I called my uncle and he said he had a friend who lived in Utrecht and that he can help me if I need something. In order to continue doing what I love to do, I decided to move to Utrecht and look for a university. Upon arriving in Utrecht, I received a lot of assistance from the staff there. I then asked if it was possible to volunteer there, and as of my second day in Utrecht, I began volunteering in the reception center. Even though the tales I heard every day were difficult, volunteering benefited me tremendously, emotionally and mentally. At the very least, I could help individuals in some manner. Fortunately, Tussenvoorziening gave me the opportunity to have a job, and at the same time, I will be able to assist the people that I love and to whom I feel a great debt. I was accepted to continue my studies at the Academy of Bouwkunst in Amsterdam on August 28th. It was one of the happiest days of my life and I loved it there. I've been there for a year and I still feel like I'm dreaming. I hope I'll be able to do so. That's the story of one of these third country nationals. And with that, I end my story.
Thank you. Sorry. Thank you, Jules, for presenting the situation in the Netherlands and for bringing the voice of people themselves. We have now some time to take some questions. I think there was one already answered in the chat. Thank you, Irina, for that. And I see there's no question for now from the audience. Jakub has just left a message to say that he would need to go. And in any case, we are in time for passing to the second panel. So I would propose, because we also had a bit of technical issues and the DG Home representative is waiting for us in the attendees area. Unfortunately, we couldn't manage to have her join as a panelist, but she is hearing us and she will be able to speak. I think I will suggest that we move on to the second part. And Frank, I already mentioned that you would be chairing this session. So I will allow Mrs. Katerina Dimitrakopoulou to speak now. But maybe first, Frank, you want to say something?
Thank you, Timona. Very interesting up till now. I think we move from a description of the legal situation and the reality on the ground to the policy in place. And we have two excellent representatives of the authorities with us. So Katarina Dimitrakopoulou, if I'm pronouncing that right. She's the head of sector integration of DG Migration and Home Affairs of the European Commission. And then Thomas Jezekwel, head of reception and vulnerability sector of the European Union Asylum Agency. Both very well placed, I think, to talk about policies and the future of the policies in place. So I guess that both of them will want to first have a little reaction on what they heard so far, and then I'll have a few questions for you. So Katarina, I don't know if the technical problems have been resolved, but if you can speak, you can speak now.
I hope so. Not sure if you can hear us. Apologies for this, everyone. It always happens even after years of Zoom.
If not, Simona, we can start with Thomas, I guess. Thomas Jezekwel, because I see he's online.
Yes.
And for him, there should be no technical issue. So, Thomas, if you're ready, maybe you can share some reflection with us first.
Yes, hello, can you hear me?
Yes.
Everything works? Okay, super. So, hello everybody. Yes, I'm Thomas Jezekwel. I'm the head of sector for reception and vulnerability at the EUAA. For those who don't know, so we are the agency of the European Union for asylum. We're based in Malta, but active in 14 member states throughout our operations. In terms of reaction, I think it was extremely interesting. I was especially interested in the legal analysis of ECRE, which I think was brilliant. And it very well demonstrates the tension between the legal framework and the reality on the ground. It's very important, of course, to reaffirm the right to housing, the importance of suitable accommodation conditions, but it doesn't translate into it in reality, as we know, in the possibility of member states to physically provide for the amount of people who came from Ukraine. This is going to be covered a little bit in my a lot actually in my presentation. So if that's okay for you, I will share my screen and present. Would like to mention also that I read the analysis from the policy paper of EANSA with great interest, and it's extremely useful. I saw that our material was referenced as well, the importance of the standards and indicators developed by UAA. So I'm just want to congratulate you on this paper before I start. So let me try to share my screen and hope for the best. Okay.
It works.
Okay.
It seems. Yep. We can see it.
Amazing. So 2 years of COVID have, everything works. Do you see my full screen or the?
We see your full screen.
What do you see? Because okay. Okay, great. Okay, so in terms of EUA mandate on and the specificities of the TPD status. So just a little bit of background, the EUA was created in 2011 as EASO, became EUA in 2022 with an extended mandate right before the invasion of Ukraine by Russia. The TPD was for us something dormant that will probably never be activated, and that was likely to be shelved in the context of discussion on the pact. Everything changed from one day to the other with the invasion of Ukraine by Russia in February 22. As you know, there was a very quick decision of the EU to activate the TPD for the first time. And we were immediately asked as an agency to help with the implementation, with the analysis, and with the let's say operationalization of the TPD. We had been supporting member states with their asylum system, with their reception systems, with vulnerability assessment, with information provision, with many things before the activation of the TPD. And it's something, so we immediately jumped into the activation of the TPD and started operations, and very quickly, for example, in Romania, in Moldova, and needs assessment in countries where which were particularly impacted by the arrival of displaced persons from Ukraine. Our main mandate in terms of reception and accommodation is the implementation of the RCD, as you know, which dates from 2013. There is a recast that was proposed in 2016, and which is in the process of being finalized. We hope, at least there is a temporary agreement on it, and we are waiting for the full implementation of the pact. In terms of TPD, reception conditions per se are for asylum seekers, people who officially ask for asylum, but many provisions of the RCD can be applied to the status of TPD. Practically on the ground, reception authorities were very often asked to step in 2022, but they were not necessarily in the lead. What I mean is the organization of immediate shelter from one day to the other at the border was not necessarily the mandate of reception authorities. It was very often civil protection, the army, NGOs, different organizations. We see reception authorities not always in the lead, and sometimes not at all in the loop, depending on the countries. As you know, there was an overall recourse to private housing after a very initial phase of, let's say, humanitarian shelter, immediate protection. But we've seen across the EU reception capacity being used. And when I mean reception capacity, I mean collective accommodation in reception centers, technically targeting asylum seekers. This was mostly the case for people more vulnerable, without a network, without access to a community of Ukrainians in the country, without support, without personal resource to settle in. But the overwhelming majority has been hosted in private accommodation, either through own resources, so ability to find housing and to pay for rent, to find a job quickly and to settle in society, which was greatly facilitated by the temporary protection status, or through solidarity in the general public with, as you know, tens of thousands, if not hundreds of thousands of places offered by individuals to host Ukrainian or people displaced from Ukraine. The mass arrival of people from Ukraine was in a context which was extremely tense already for reception systems. Here I'm talking about reception systems in the sense of catering for people who have asked for asylum and who are currently in procedure, so reception in the strict sense of the RCD. There was already a conjunction of several crises across the EU with a high number of arrival, mixed migration flows, as we've seen, especially in the south of Europe, in Spain, in Italy, in Greece, but also throughout the Western Balkan route. Strong pressure on asylum and reception systems, and what is the, in our sense, the most problematic aspect, a very low outflow from reception. What do I mean is that a reception system works if there is, if let's say the inflows of people getting in the system is comparable to the outflow of people getting out of the system because they have received status or they are being rejected and returned to their countries. What we've seen, especially in the west of Europe, is very low outflow in the sense that either asylum procedures are very long and last for too long, and people stay in reception for much more than they should, sometimes amounting to several years, very, very low enforcement of Dublin return decisions, very low enforcement of return decisions for people who are definitely rejected. And for people who receive refugee status or another form of protection, very high difficulties to find housing in the, let's say, mainstream society because of the high prices, because of low availability of social housing or no availability of social housing, and very low availability on the private market. It's something that goes beyond what a reception system, reception authority can do. It's a societal problem, a problem for society at large, as you well know in terms of access to housing. The capacity of, well, occupancy, sorry, it's a mistake on my part. Occupancy in several member states has consistently been above 100%, meaning that there are more people who should have access to reception than the actual number of reception places available in the country. I'm sure you've seen that in the Netherlands, you've seen that in Belgium, in other countries where if you have, let's say, 30,000 places in your reception system, and suddenly you are supposed to house 45,000 people, it's quite a problem, and you cannot magically come up with 15,000 additional places. Adding capacity has limits. You cannot grow indefinitely, and it's not always possible, sometimes for financial reasons, sometimes for political reasons, meaning that the budget is there, but there is no agreement to open a refugee reception center in this locality or this locality, and this can create a huge problem for a reception system to grow. I mentioned it was a let's say whole of society issue. Reception authorities cannot solve housing crisis, high pressure on public services beyond what is, of course, their mandate. So in a nutshell, without the solidarity and recourse to private housing, the situation whereby EU at large receive 5-6 million people in a few months will have been absolutely unmanageable through the classic reception system, which is not equipped to deal with these numbers. And so, as I think it was someone from the Slovakian Reception Authority saying very clearly after, I think it was already in May 2022, where solidarity bought us time, otherwise we would have just collapsed. In terms of work by EUAA, we have produced two documents in 2022, among other things, but a guidance on private accommodation for displaced persons from Ukraine, which was focusing on recommendation on emergency placement in private accommodation, and a guide on modular approach to reception and how to design reception centers in emergency settings or temporary settings through the use of container or, let's say, modular housing at large. This second one was not targeting Ukrainian initially, but has led to the constitution of temporary reception centers, accommodation centers, who have received Ukrainians according to our designs, according to our principle. Here with a focus on the EU reception standards, so with suitable accommodation, minimal standards for receptions, protection, assessment of vulnerabilities, and so on. So how to design a center to best respect these standards. So this guidance on private accommodation was to guide relevant stakeholders for the matching of displaced person with available private accommodation, complement the effort at national, regional, local level, not to replace them, of course, and mostly to ensure safeguards for persons in need of emergency accommodation, but also for the hosts, because the situation had a reason where it was actually the host who found themselves in vulnerable situation. It was feeding into ongoing initiatives at the 10-point plan from the EU Commission, the Safe Home Initiative, which is currently going on and on which we have been extensively consulted. And we, of course, in this guidance reaffirm our EU existing reception standards and indicators for suitable accommodation. Bearing in mind that our standards are mostly let's say, targeting collective accommodation centers and less private accommodation, although they should be valid also. For this guidelines on modular approach to reception, So I already explained, we outline principle for the design and management also of reception center, and what principle you should follow when setting up and managing such facilities. We have applied it in the field when we have been asked to create, to complement available reception capacity through our own framework contracts with containers and setting up reception centers. And as I said, it's fully applicable to displaced persons from Ukraine and beneficiaries of the TPD. Beyond, let's say, this brick and mortar dimension, we have also been extremely active on information material on TPD, producing quite quickly, in matter of a few weeks, leaflets for adults and children, supporting member states to provide same information about the rights linked to the TPD status. We have produced material in child-friendly and age-appropriate language. We have also been very, very careful with issue of assessment and identification and assessment of vulnerability, informing people who might have special needs about the possibility to ask for specific help. And we emphasize the importance to obtain information from clearly identified information hubs and not believe anything they hear and the latest rumor, because as we know, there was many conflicting information at the start, and many people in vulnerable situations who could have been victim of people with extremely bad intentions. On TPD, we have also produced what we call a who is who, which is an overview of the implementation of TPD in each member states with information tools linked to relevant website. What are the procedural steps depending on the member state? What are the possibility for reception accommodations? What are the specific rights? Who are the official stakeholders for each dimension? So for housing, for education, for access to social security, for access to labor market. So it's something which is regularly updated, and it's still online. As you know, the address is here on the slide. You will find it easily if you go to whoiswho.uaa.europa.eu, because we have whoiswho on asylum procedure, we have whoiswho on reception. So this one was created ad hoc on the TPD. We have also published earlier this year a year in review on providing temporary protection to displaced persons from Ukraine, taking stock a little bit of everything that happened with different aspects of the TPD, different dimensions. Two interesting ones for us here will be so one on reception and registration, how to conduct it in the best manner. And I must emphasize that many things that we've learned through the mass arrival from Ukrainian and displaced persons from Ukraine are feeding into our reflection on how to act in case of mass arrivals, regardless of the nature of the migration and of the arrivals. How to act at the border, how to set up one-stop shops, how to set up registration and reception in an emergency in the most efficient and protective way. We have also seen a lot of bridges being built, let's say, between authorities. National authorities were very often not able to do on their own, and they had to coordinate closely with regional and local authorities to manage, especially second line reception capacity. When we say second line, it's like what comes after the emergency, after the temporary nature, after the immediate shelter that was provided in containers, in tents, in rubber holes at the borders, and where could these people be dispatched to a more suitable and sustainable reception conditions. We have also provided a lot of training to NGOs working with national governments, in conjunction, of course, with national governments. But when they were using NGOs or counting on NGOs in the role of an implementing partner, UAA has been training these NGOs quite extensively on the SEAS, on the TPD, on information provision, on assessment of vulnerabilities and identification, etc., etc. So this has been quite important. Encourage you to have a look at this report. In any case, it's extremely interesting. We'll see if we produce a second edition in February 2024. I will finish with a specific aspect of vulnerability, just to mention that the UAA and my sector has produced vulnerability tools which are relevant for any migration context, so asylum, mixed migration, TPD, it doesn't make a difference. We have the IPSN, which is the identification of persons with special needs, which is a very, very extensive tool going throughout any indicator of vulnerability and trying to do a thorough identification of the special needs of the people for asylum procedure, but also for reception. We have what we call the SNVA tool, which is a special needs and vulnerability assessment, which after the identification goes much more into depth to assess the vulnerability and special needs of the applicants, and allow to go to the next phase, which will be the referral, on which we're also producing a tool. So once you have identified and assessed vulnerabilities, what do you do with that? To which professional do you turn? What can you do yourself? What can the reception authority do? What needs to be done by specialist organizations? So we are building up a referral tool in that regard. And finally, it's also one of the lessons for us of this situation, of the mass movement from Ukraine, will be that we are working now on what we call the VPI, so Vulnerability and Prey Identification Tool, which is to allow for quick screening of vulnerabilities in case of mass arrivals. Because we found out that our first tool, the IPSN, is good in normal situation, but in situation where you actually see hundreds of people going through a registration center, it's too lengthy. So we are producing something which is much more agile and able to do a kind of a triage on vulnerability and on special needs at the border in case of mass arrival of people. So it's something we are developing currently, and which we are working with member state authorities, but also with Frontex, with FRA, and with Europol. So I will stop here. I'm happy to answer any question, and I will stop sharing my screen.
Thank you very much, Thomas. That was a comprehensive overview of what has been done and what is available. I'll come back to you with a question about the future as well, but so that you can prepare. But I think, Simona, if I'm not mistaken, Katarina is able to speak now. At least the way I see you shows all in white, so I think you can speak, Katarina. So floor is yours for the first reaction.
Can you hear me now?
Yeah, we can hear you.
Hello, can you hear me?
Yes, we can hear you.
Very good. I have so many issues to connect. I really try connecting, so apologies. I've also missed the first presentation, which is a pity, but hopefully you will circulate also the presentation so that we will be able to have it also, you know, in paper. So many thanks for this very interesting discussion. I have taking notes, and since I do not have access to the link, I would also be interested in the study that we were discussing about Poland and all these interesting elements. So my name is Katarina Dimitrakopoulou. I'm the head of sector responsible for integration in the European Commission, and we are working together with our colleagues who are dealing with migration management and, of course, with the unit monitoring the implementation of the Temporary Protection Directive to make sure that, as people have said, there's no asylum system that is crashing, and that we find the best solution in a suboptimal situation to deal with this crisis. So let me just make a couple of points that are important so that we're all on the same page. As you know, responsibility for housing policies and also issues like quality of accommodation, etc., it is national competence. And this is why it is for member states to set out their policies on this, including on, for example, providing allowances or housing support. But of course, these rules have to be in line with the Temporary Protection Directive. Now, despite the fact that we do not have competence, we do try to support and assist member states, local, regional authorities, and everybody else to address these challenges. We are trying to promote inclusive housing solutions, And we have looked at quite a few innovative housing solutions that have been developed in different EU countries, and also we have funded a lot of projects in this sense. Because we do believe, and we have heard it, that adequate and affordable housing is key to successful integration. As you know, housing conditions also have a strong impact on the employment opportunities and also on getting children to school. So this is also something that we are highlighting in the action plan on integration and inclusion that we have, and it covers the years 2021 to 2027. And at the same time, we are looking at all these issues and also the role of the local and regional authorities, because this is also an important one, and sometimes it is not easy even for them to coordinate with the national level. So if you want, the main crux of the issue is that a housing competence, it is not with just one actor. It depends on each member state, but as also, I think it was Mr. Van Dam who mentioned it, but it is split between different ministries, yeah? And I think that this is a problem, that you have many different ministries who are dealing with housing issues, and you also have different ministries that are dealing with migration and inclusion. So it is very important to have a coordinating mechanism. This is the optimal solution if you want, because it is extremely difficult to bring in all these factors and to really have, you know, a coherent policy in this respect. So this is a big challenge, I think, for all member states, independently now of the Ukraine crisis, but it has been accentuated through the Ukraine crisis. So for us, for the Commission, of course, you know about the Temporary Protection Directive, about its scope. We have heard also, you have heard, I could not get in yet, but we have heard about what it provides. But basically, it is important also to explain that after the Temporary Protection Directive, we have also followed up with a couple of communications, one of which is on making Europe ready to meet the needs a couple of months after we have, actually it was in March last year. And there we already said that more long-term housing solutions might need to be included into member states' broader housing policies. And then to reinforce this point and to look a little bit more into what happens now that we have the pressure, but at the same time we have private people solidarity because they have opened up their homes, we looked at a 10-point plan together with the French presidency, and there we included an action on looking a little bit at the reception capacity and implementation and how these can be, you know, the offers that were there in the member states could be matched with those who were in need of support. And this is how the Safe Homes Initiative was born, and it was also, you know, announced together with a whole package of measures to help people, but it was also not a one-off. We think of it as a continuum a little bit. So first we had the Safe Homes Guidance, which was a document drawing on the early setup of these private accommodation schemes. And it was also drawing on the EUAA guidance that was mentioned before on how these schemes should be set up that had come out in the meantime. And we look at the experience, this first experience, and provided some guidance and good practice so that the member states, but also the regions and the cities and everybody else who were involved, they could set up these private schemes in a way that it would be safe, the accommodation also for the people, but also looking at the issues of the host a little bit. And then in November 2022, building on this guidance, we have awarded 5.5 million euros to the International Federation of Red Cross to conduct a project which will look a little bit and assess the needs for those who need housing and are fleeing the war in Ukraine, and look a little bit at all these issues of matching with private offers, but also, and more importantly, if you want, support for the potential hosts or the ones who are hosting the people, and exit strategies. So a little bit what will happen the day after. It's a little bit what we have heard, because thanks to the solidarity, we had this first wave, but then after a certain period of time, and as the war persists, the issues of, you know, how can then these people become independent emerge, and this is an important one. So we have seen, I can give you some examples maybe later on, but what we have seen is that very good, promising models that can foster inclusion and also community building, but also help these people become independent, are approaches that are based on partnerships. And there we're thinking of private, public, also local, regional, and different levels of governance, and also entrepreneurs, foundations, so the philanthropy, etc. Then there's also solutions with co-housing, and also solutions that are bringing into the housing inclusion part the possibility to get employed and to link social services to these housing offers, which is it is very, very interesting, because it means that these people, it's not just about giving them the roof over their head, but it's also about equipping them with a better chance of not becoming homeless when this end finishes, or, you know, to have a smooth transition. For example, in France, we have heard that there is a program named HOPE, which is accommodation, counseling, and pathways to employment. And they teach people, you know, French, and also they get vocational training in jobs that are in demand. And they also get accommodation. So if you want it, it's a one-stop shop that gives them the tools to then find their way and become independent. And by the same vein, in Spain, for example, there are specialized teams that help beneficiaries find appropriate accommodation. And this is a part, a second sort of part of the reception, and they call this preparation of autonomy. And this appears to also be a very, very good practice. So we have quite a few examples like this, but I would like to stop here, because I think that you may have questions, and also to the others, and we can have a discussion, and I'm very happy to come back or explore other topics. Thank you.
Thank you, Katarina. Maybe, like, we're a bit pressed for time, but and I had prepared a few questions, but I'll limit them to two, and then we can open up for debate, because there is already some questions on the chat. You can choose who wants to answer, but my first question would be, we heard from the reality on the ground, and I think some of that reality could be considered not in line with the EU legislation, as is described in the Temporary Protection Directive. Are you monitoring these situations, and do you consider legal actions against member states if they don't respect the law? Because it's fantastic to see all the support measures that are in place, and support is really helpful and guidance is helpful. But what if the guidance doesn't translate into situations that are in full respect with EU law? What happens then? Like, are you monitoring these violations, and do you plan to react, or have you reacted if the law is not respected? And then in relation to the housing, like the emergency solutions and the longer term solutions, it's good to have the guidance related to private hosting in the Safe Homes initiatives. That's great, but it is only a solution for some time. And I see that there is some interesting projects being identified, but is there something more ambitious in relation to longer-term solutions, providing longer-term solutions for Ukrainian refugees. And if that's the case, is there not a plan somewhere to have the wider housing sector involved in that? Because I guess they are the ones that provide or can potentially provide solutions. And I have the impression that at this stage, certainly at European level, they're not necessarily heard or involved in that kind of exercise. So I don't know, Thomas, if you want to start, and then I'll move on to Katarina again.
Right. On monitoring of the implementation of the TPD, it is something that we can only do, of course, through observation and reporting. We don't have any mandate to enforce the TPD and member state, and I don't think there is any plan to do so. UAA will soon have a monitoring mandate related to the CEAS, related to reception and asylum matters. TPD is not yet, as far as I know, included into this. So on this, I would let Katarina reply really on how the EU Commission is monitoring and thinking or not to enforce the provisions. On the wider housing discussion, before working for UAA, I was working in Brussels for Eurocities, and the issues of housing was, of course, huge on social and affordable housing. I think it's beyond the current crisis with Ukrainian, and of course it puts a big spotlight on this. But housing issues did not start in March 2022. Involvement of housing professionals with the EU has been piecemeal, has not necessarily be sufficient. And as I was saying in my presentation, it's something which is much bigger. It's about affordable housing. It's about affordability of housing, literal places that sometimes are not even available for people who are born and raised in a country, and of course is even more problematic for people who just arrive and who are in a vulnerable situation. So I think it's a much wider debate of massive public investment in affordable housing, on which I have no solution, of course, to offer at my level of migration professional. And yes, I will stop there.
Karina, I think you're still there. Yep.
Yes, I'm still there. Thank you. Yes. So just to pick up on a couple of things that you mentioned. Well, first of all, the Commission is always monitoring the application of the directives, and there in the field of reception, it will indeed look at identifying risks in the transition, in particular from the emergency accommodation to longer term solutions. And there we will also be looking at vulnerable individuals, as we have heard, who are facing specific issues, because indeed with good practice and getting people to work, then there is a big part of the people who will hopefully manage to become self-sufficient. Now, the other important element is that the implementation of the directive, it will require, of course, continued support to make sure that all the challenges that we have heard, and we know them, of course, because we also have bilateral discussions with the member states, but the situation is also changing over time, so it's also a little bit difficult to keep up, and that appropriate transitions and contingency plans are in place, because we need to be prepared and as I said, to adapt to moving ground and future situations. One very useful instrument that we have in this respect is the Solidarity Platform, which I think that many of you may know. This is a forum that we have together with the member states, and there are also representatives from NGOs, sometimes from UNHCR, IOM, and we're actually the UAA is also very often there, and we are there also discussing quite often. We are discussing these issues, and we are trying to ensure that there is this EU coordinated approach. And in this framework, we're also engaging with member states. So, we are mentioning all these issues. And the last meeting that we had specifically on accommodation issues, it was, I think, just before the summer. So we have touched base on this again, and we have discussed also specific problems. But one thing is clear, that there's not a silver bullet. So, you know, when member states, they are under a lot of pressure, and also sometimes budgetary pressure from all ends, it is not very easy to find a solution that will, you know, at the same time satisfy, of course, what needs to be there, but at the same time make it, how should I say that, acceptable also at the political level. I'm not saying that because, you know, there are basically there are many different issues. And the other thing that I think that we should not forget is also that, as I said, the competence is with different ministries. So sometimes, from what we have understood, it's also a way and a challenge that is linked to coordination between ministries. Yeah. What we have done, that I have forgotten to say, because I did not mention the different funding strands, but as you may know, there is the Cohesion Policy Fund, there's the Home Affairs Funds, or AMIF, yeah, that has a specific component also on reception and integration, but there is also the technical support instrument, which is something that DG Reform is leading on. And for their big topic this year, we have actually suggested, and they have accepted, and we are now having a call to help out with the challenges linked to accommodation and housing, and the reception-related challenges that are the first part of the problem, if you want, or of the challenge. And there, what we will do is that we will help the member states build capacity to tackle these issues, you know, more effectively and in a more efficient way. So, and this is on top of all the other funds that we are having from the DG Home side. So this is one of the things that I think will help, because the problem is that sometimes we look at it as a one-off, but actually these are long-term issues that you cannot just fix with a quick fix. You know, you just need to take time and reorganize things and really think through your national strategy. And when the competence is split between ministries, it is not very easy to do that.
Sorry to press you a little bit, but very follow-up question, very quick follow-up question, Katarina. Like you heard from our Polish colleague, Jakub Wilczek, that, and this was a very small research, that on the basis of that research, probably in Poland, there is hundreds of Ukrainians living in homeless situations that could be considered violation of the EU Temporary Protection Directive. Would that be sufficient for the European Commission to sort of consider some kind of legal procedures or infringement procedures? Or how does it work? Like, can an organization like FIANZA or colleague organizations be helpful to help you monitor the current situation?
I think that this is very good. I mean, as I already told you, that I would be interested, but not just for my intellectual curiosity, but also for, you know, for the work and for our information, that we would be interested in receiving information. We have colleagues who are actually on the ground in Poland, and they are discussing, and I know that they know about many issues. They are discussing with national authorities. They're discussing also with local regional authorities that are very, very active in Poland. And they're also discussing with other stakeholders, and IOM, etc. But if you have good research and, you know, research that shows the numbers and the issues and explains a little bit, gives a little bit of context, then of course it would be interesting for us to find out about it, because I think that we are open to receiving all sorts of information that is relevant. and then take it into consideration. And as I said, we have these discussions at the Solidarity Platform, but also bilateral discussions with many member states, and in particular the ones bordering Ukraine. So this could be a way in which you could help make your point very, very strong.
Thank you. I think this can be the start of a longer-term cooperation between yourself and some other organizations. Thomas, you must have seen that there is a question in the chat for you specifically. It's referring to the pre-identification tool that you were mentioning in your presentation, and to what extent artificial intelligence will be used in that tool. Quite a technical question, but probably very important and with a lot of possible consequences.
Very easy to answer as well. Not at all. So it will be purely human managed with people who are not robots. So yes.
So at least on that front, no reason to worry. I guess the answer
no
is
reason to worry. No. If you are interested in this topic, the UAE has published or will publish its digitalization strategy, where we talk about artificial intelligence and so on. But it's not applicable to the tool I was just mentioning.
Okay. Simona, I don't see any other questions in the chat, and we're running over time already, almost 10 minutes over time. So I guess it's best if we close here. Is that okay, Simona?
Yes, I think so. Thank you to everyone for the patience, and apologies for any technical errors. Thank you to Irina as well for staying with us and joining for her presentation. We'll stay in touch with updates and send information to all participants as a follow-up. And yeah, have a nice day, everyone. A good week.
Thank you so much.
Bye-bye. Have a nice day.
Bye.
Bye.